In this video we want to talk about intellectual property. Now this is one of several videos on this topic on the course, and needless to say all of them should be consulted. So in this particular case we're going to talk about copyright. Now copyright protects a wide variety of material, including writings, artwork, music, films, computer program, broadcast material, and all design and original work. So copyright covers a lot, not just written material, artwork, music, films, and so on. So it's a very wide-ranging term. Copyright belongs to the creator and applies from the time of creation. So copyright belongs to whoever created that original piece of work. Clearly the work we're talking about here must be original to that particular person, because otherwise he or she is taken from somebody else. So copyright belongs to the creator and applies from the time of the creation. The copyright symbol was often seen as a C with a circle around. It's not necessary for protection. You don't have to put it on. People sometimes put it on to writings just to say that they're aware of copyright laws and rules, but the symbol itself is not necessary as a means of protection. Generally, copyright applies to permanent copies and material placed on the internet. So copyright really applies to permanent copies, and if the material is placed on the internet, copyright will apply there as well. Screen displays and temporary RAM storage are not regarded as copies, but downloading to a hard drive and printer does count as copies. So if it's temporary displays on a screen, or temporary RAM storage stored in random access memory for a short space of time, that's not regarded as a copy. But if it is stored on a hard drive and printer, then that does count as a copy. Infringement of copyright occurs when materials or a material is used without permission of the owner. That's when infringement happens, when it's used without permission from the owner. Some copying is permitted in the case of research, academic pursuits, and when only a portion of the material is used. So academic works tend to be referenced, and that's acceptable. But only a part of the work, perhaps a chapter or 10% of the book or whatever it is. So depending on the rules. But the point is that for academic research the rules are a little relaxed. Now patents or patents. This gives an exclusive right to produce a device, substance, method, or process that is new, inventive, and useful. So it's a legal protection. A patent is a legal protection for the inventor or the originator of the idea to give that person a chance to reap the rewards of his or her hard work. A patent must be applied for at the patent office. There is an office where the patent must be submitted. Separate applications must be made for each country, since there is no world patent. So different countries have different rules. So the patent must be applied for in different countries. Trademarks. Well, a registered trademark given the owner exclusive rights to use, license, or sell the protected item. So a registered trademark imparts this exclusive legal right to the owner to sell or license the protected item. So the trademark indicates that this is a protected good. A trademark can cover words, pictures, sounds and smells. All of those may be trademarked. If they are unique, if it's a word, then that becomes a trademark. Coca-Cola is a trademark. Pepsi is a trademark, I think. As are lots of other words. A picture may be a trademark. A logo, or a sound, or a smell even. The use of registered words in a metal tag to increase hits is an infringement of trademark. So the use of a registered word as a tag on, for example, on a website to increase hits. Now that's an infringement of a trademark. So, for example, if someone puts up a website and puts up a string of search terms associated with that website, and they use words which are used by a company as a trademark, then they are deceiving the people who are using the search engines, because they're being guided to their site wrongly. That's bad. But also they may be associating a reputable product with a not very reputable website. So it's not fair to the owners of the trademark that their words should be used in this way to generate hits for someone they don't know, they have no contact with, they have no right over it, and they're using their trademarked words to generate hits for their site. And of course, misleading all the people on the internet who use search engines to try and find information off the web. Domain names. Well, a domain name is not a trademark unless it is registered as such. So a domain name is not a trademark. Squatting occurs when famous names are registered as domain names. Sometimes people try to register sites, particularly if there's a new extension being released. The extension being after the dot on a domain name. If a new one is released, some people try to register reputable companies with that extension. Obvious targets would be Coca-Cola, Microsoft, all of those. And then they squat, they hold that name. They're holding it deliberately, hoping that the company will buy it off them for a vast sum of money. And their argument is that they got there first and they're entitled to register whatever name they wish. But it's clearly done not to put up a site or to use that name. It's squatting. It's there to try and extract money from the owners of those words, those registered trademarked words. So squatting on the internet is used. It's not condoned, and it's got a bad reputation, so it's probably in decline. But having said that, it'll probably also continue. The purpose of squatting is, as I said, to sell for a profit. It's now considered illegal in many countries because it's not meant to do anything. It's not helping anybody on the internet. It's simply people jumping in, trying to register a name on the internet that's clearly associated with a reputable product, a big company, trying to register that name, and if they're successful in registering it, they then want to sell it for a profit to that company. Misspellings have also been used to confuse browsers. This practice is also on a weak legal footing. Misspellings sometimes, if they're stealing access to a particular name, they may misspell it or just move a couple of the letters around. It looks the same and it would be read the same, but it's just misspelt, just very slightly. Again, the purpose is to confuse the browsers, confuse the search engines. So intellectual property, well, the idea behind intellectual property is that the owners of the ideas should reap a reward from their ideas, and this will encourage them to continue to be innovative and look for new ways and look for developing new material. So an artist who is a painter, let's say, should be able to enjoy the fruits of his or her work. A photographer should be able to enjoy the fruits of his or her work as well, and so on. And it's not right that someone should take pictures of the pictures and then try to sell them as originals. That is stealing. And that's what this whole area of law is trying to stop. It's trying to make sure that the owners, the legitimate owners of the ideas, should reap a reward and be protected from others stealing their ideas. So that's all we're going to deal with in this session. So let's leave it at that and say thank you for watching.